So hello and welcome everybody to the Civics Project hosted by Repair. I am Beth Ribet, the Director of Repair and the host of the Civics Project. And our subject matter today focuses on the Civil Rights Act of 1964. Before we begin the program, I'd like to start with a brief land acknowledgement. Repair acknowledges the Gabrielina Tongva peoples as the traditional land caretakers of Tobangar, the Los Angeles Basin and South Channel Islands. And we are grateful to have the opportunity to work for the Tarahatom, the indigenous peoples in this place. We pay our respects to Hanukvatam, the ancestors, Ahihiram, elders, and Eohinkem, our relatives and relations, past, present, and emerging. As we dive into the subject of the Civil Rights Act of 1964, it's very important to think about the historical periods that predated its passage. So the formal end of US slavery was in 1865, 99 years before the passage of the Civil Rights Act of 1964. And through several constitutional amendments, the end of the Civil War, or that period, marked an elimination or eradication of some aspects of US law that were meant to uphold white supremacy. So more specifically, the 13th Amendment to the Constitution formally ended slavery. The 14th Amendment established a right to citizenship regardless of race. And the 15th Amendment established voting rights for men of color. So basically for all men regardless of race, as it was phrased in constitutional terms. Despite these initial steps, practices of racial discrimination and segregation and subordination remained entrenched in various aspects of US law and policy. So during the period when each of these amendments were passed and following, what we saw was state and municipal laws and measures and informal practices and procedures which eroded prospects for racial equity or justice. So some of these dealt with the subject of voting. For instance, poll taxes were a good example of the ways in which states and municipalities could create barriers to voting by making it costly to do so, by establishing a tax in order to vote. Literacy tests were also particularly noxious ways in which Black people were prevented from voting in the United States. And we have to keep in mind that the practice was to minimally, if in any way, to fund schools that reached Black and brown children, and to deny access to resources that would facilitate education, and then to take advantage of the resulting in educational inequities to deny people the right to vote. So literacy tests functioned in concert, essentially, with educational discrimination to prevent voting access. There were also a whole host of what we call Jim Crow segregation laws. And the viability of Jim Crow laws meant to keep people segregated in various kinds of sites and spaces based on race, was tested in the Supreme Court in 1886, 20 years after the end of the Civil War, in the case Plessy versus Ferguson, through which was established the legitimacy of the separate but equal doctrine. So essentially, federal law, which establishes that it is okay to segregate people based on race, and doing so does not inherently violate a right to equality or equal protection, for instance, under the 14th Amendment to the Constitution. Additional state and municipal measures which tended to erode prospects for racial inequity and justice were actually direct participation in or complicity in violence. And I'm speaking specifically of the KKK, the Ku Klux Klan, and a few of its offshoots. And we have to keep in mind that certainly in the 19th century and early 20th century, Ku Klux Klan, it was not unusual for municipal officers like local law enforcement or officers of the court to also be active members of the KKK in some parts of the country. And so one of the things that we saw is that regardless of what federal or state or municipal law was on the books, the use of violence and terrorizing acts directed against Black, sometimes Indigenous, sometimes Latinx communities was a powerful way in which officers of the state and municipal and state levels, and sometimes federal, also participated in maintaining racial inequity. So essentially, right, we have the 13th, 14th, and 15th Amendments. And then we see a subsequent century in which even though legal slavery has ended, the maintenance of structures designed to make sure that white people are dominant plays out continually and reinvents itself, reconstitutes itself for a century subsequently. Now, the civil rights era, as we think about it, is generally dated between 1954 and 1968. So we can definitely think about the Civil Rights Act of 1964 as towards the center of that era, a little bit past the middle. And it's also important to know that there were two actually weaker versions of the Civil Rights Act that were passed. So Congress also passed, and the executive branch at the time implemented a Civil Rights Act of 1957 and a Civil Rights Act of 1960. And both of them were, as written, just very weak. They didn't do much. They didn't give people many rights. So they mostly said, oh yes, civil rights should exist. And there should be a commission that looks into it. And didn't give a lot of enforcement powers to anybody to regulate civil rights. So in this era where legal systems formally and informally have been maintaining white supremacy for a century, we start to see the upsurge of the civil rights movement. And one of its aims is to start to create civil rights, literally, in US legal systems, to change the law so that it will be more supportive of racial equity, less supportive of white supremacy, of racism. So John F. Kennedy is president, and he initially, when he takes office in the early 60s, is resistant to the idea of doing anything about really advancing civil rights. But as protest is continuing and gaining increasing support, gaining more media attention, eventually the president comes around and decides, okay, we have to do something that's not just sort of empty paper to address civil rights. And so he proposes the Civil Rights Act of 1964, and he does it against very strong opposition from Southern members of Congress. Now, JFK will be assassinated, as many of you know, before the Civil Rights Act of 1964 can be signed into law. So after his assassination, it reaches the executive branch under the presidency of Lyndon B. Johnson. And LBJ signed the Civil Rights Act of 1964 into law. And part of the historical record is that he actually used at least 75 different pens to sign the Civil Rights Act, and then was giving them out essentially as mementos to some of the key figures, both in Congress and also major civil rights leaders like Martin Luther King, who were attending to mark the moment. So introduced by JFK, though not without some reluctance on his part, and signed into law by Lyndon B. Johnson. The process of passing the law in Congress was extremely contentious. So one of the things that Congress people can do to try to block a piece of legislation is to introduce what are called hostile amendments. So amendments that contradict or counter or change vital parts of the act, and then have to be debated, which can slow it down or might gain enough support to change the act into something which then would not get passed. So the opposition to the Civil Rights Act of 1964, again, primarily coming from the US South, introduced more than 100 hostile amendments that had to be defeated. An interesting element of this history, though, is that one Virginia Congress member introduced an amendment which added to the act a ban on employment discrimination directed against women. So basically saying sex discrimination in employment should not happen. Now, this seems like a good idea in our contemporary context, but the Virginia Congress member who introduced this amendment did so thinking the idea of equal pay, equal rights for women in employment was so ludicrous that if this amendment were included, then people would not vote for the bill. So interestingly, the Virginia Congress member who added sex discrimination into the bill through this amendment did so because he thought it would cause the bill to fail, because the idea of prohibiting sex discrimination was in his mind so ludicrous. However, the amendment was actually incorporated into the act and helped to legitimate sex discrimination as an area of law understood in civil rights law. The hostile amendments were not enough to stop the passage of the act. And so the Southern opposition to the Civil Rights Act of 1964 launched a 75-day filibuster in which they refused to let the act go to a vote by continuing to give testimony, again, for 75 days during all the hours that Congress was in session. The record in that time was by a former Klansman, KKK member, and member of Congress, Robert Byrd of West Virginia, who actually spoke consecutively for 14 hours during the filibuster. So they managed to stall voting on the act for 75 days, but eventually gave up. And the act went to a vote and was passed in both chambers. And as noted, signed into law by Lyndon B. Johnson. So let's talk about the Civil Rights Act of 1964 and what it actually contains. It creates protection against discrimination. That is its broad mission. And initially, it wound up doing so on the basis of race, color, sex, religion, or national origin. So those were what we think of as the protected classes of people, or protected classes, named in the Civil Rights Act of 1964. Later expansions of the Civil Rights Act, so not in these years, would cover disability, the elderly, and also women in college sports. And in 2020, the Supreme Court also expanded the understanding of one of the titles of the Civil Rights Act of 1964, Title VII, which deals with discrimination in employment, and said that it should also be understood as applying to LGBTQ people. So restricted to employment, there's now an interpretation by the Supreme Court that the Civil Rights Act of 1964 also today applies to LGBTQ people. So originally race, color, sex, religion, or national origin, later disability, the elderly, and women in college sports, and more recently by the court just last year, LGBTQ people in employment. So I want to walk us through what the major provisions are of the Civil Rights Act. There are 11 of them, and each one is called a title. So Title I of the Civil Rights Act of 1964 addresses voting rights, and one of the things it explicitly does is ban literacy tests as a barrier to voting. Now, for those of you who've been attending the Civics Project before, or listening to prior episodes, you may have recalled from our session on Voting Rights Act of 1965 that it also created a lot of protections in voting. So the Civil Rights Act of 1964 and the Voting Rights Act of 1965 are both understood as companion legislation coming out of the Civil Rights era, and in this case, just 1 year apart. But Title I of the Civil Rights Act did some initial things to establish voting rights. So the Voting Rights Act of 1865 basically expanded further and enumerated and delineated more protections to more strenuously protect voting rights. Title II of the Civil Rights Act of 1964 covers what are called places of public accommodation. And in civil rights law, this can mean places where you literally stay, like hotels and motels, but it also can mean all sorts of places that we go because they're open to serve the public, like restaurants, gymnasiums, movie theaters, pretty much anything that you can think of that's a public business, which people can visit. So Title II, for instance, prohibited discrimination in ways that were very traditional under the Jim Crow era, such as segregated lunchrooms. So restaurants, any sort of place that's open to serve the public, no discrimination allowed. That's Title II. Title III deals with what are called public facilities. And since they both have the word public in it, it can be easy to confuse Title II and Title III. But the law defines public facilities as things which are run by government, state or municipal governments. So for instance, racial discrimination or sex discrimination in a program of the state that you live in or the city or the county that you live in would be prohibited rather, under Title III of the Civil Rights Act of 1964. Title IV of the Civil Rights Act of 1964 bans discrimination in public education, no more segregated schools. Now, this act comes 10 years after the Supreme Court decision in Brown versus Board of Education, which had previously found that school segregation was unconstitutional. But Title IV of the Civil Rights Act of 1964 basically expanded on Brown versus Board of Education to create a little more strength and a little more protection in order to prohibit discrimination. It also addressed potentially or had a more expensive conception of discrimination that wasn't just about segregation, but any way in which discrimination might play out in public education. Title V of the Act created a commission on, or rather I should say expanded the powers of the Commission on Civil Rights that had been created previously under the Civil Rights Act of 1957. Title VI of the Civil Rights Act of 1964 says, if you're getting money from the federal government for a program, then that program has to be non-discriminatory. So anybody taking federal funding, right, has to comply with non-discrimination requirements in the programs that use that funding. So that again is Title VI. Title VII is one of the most impactful, and it created a right to equal opportunity in employment. So this Title VII is where we go for equal opportunity claims or complaints, and in anything to do with private employment, state employment, and in some instances, federal. So Title VII deals with employment, and it also creates the EEOC, the Equal Employment Opportunity Commission, which has a certain set of powers under this law, and they've been expanded over time, to investigate complaints of discrimination and to take action. So the EEOC can choose to sue, for instance, a discriminatory employer on behalf of the federal government if it feels that it is acting particularly badly. Title VIII of the Act was basically created to guarantee non-discrimination in voter registration. So it expanded a little on the voting rights covered in Title I, and to collect voting statistics. So again, a bit more to make sure that discrimination in voting was combated. Title IX, and people often confuse Title IX of the Civil Rights Act with Title IX of the Education Amendments Act. So when you hear people talk about Title IX, usually they're talking about the rules about sex discrimination in education, but they're not referring to the Civil Rights Act of 1964. That Title IX is from the Education Amendments Act, which was passed in 1972, 8 years later. So Title IX of the Civil Rights Act gives the Attorney General the power to intervene and take basically cases out of the courts and have his or her own hearing about civil rights cases which deal with the 14th Amendment right to citizenship. So it basically gives the Attorney General extra authority over cases they deem important dealing with civil rights in some instances. Most cases, this is never going to come into play because there are far too many for the US Attorney General to deal with. But when the Department of Justice, when the Attorney General decides, you know what, this case is just particularly important, you need to investigate it thoroughly itself, the Civil Rights Act of 1964 created that right, again, under Title IX. Title X of the Civil Rights Act of 1964 creates what's called a community relations service. So it empowers the federal government through its entities to assist state and municipal entities in doing things like dispute resolution. Basically, it creates ways to work things out, since not every case is going to be adjudicated or advanced by the Attorney General, for instance, or taken up by the Eeoc. And so it creates this, investment in doing more dispute resolution, more investigation, and supporting that at the state and local level. And the last title is really just sort of the catch-all. They literally, describe it as miscellaneous in the title. And it has a number of little things in it. For instance, it says there's no double jeopardy, meaning if you are facing a legal claim for a violation of this act, you can only be found guilty of it once, or not guilty. You can't just be tried twice. In cases where someone's not complying in the law, which is civil, it doesn't go to the criminal courts unless someone is in contempt of court. And then they can face, in a civil or criminal court, if the judge charges you as being in contempt, that's a crime. So interestingly, the Civil Rights Act of 1964 says that if you're charged with criminal contempt in a civil rights claim arising under this act, you have a right to a jury trial, right? So that's an example of some of the miscellany that show up in Title 11. So voting rights, public spaces run by governments and programs, public education, expanding the Commission on Civil Rights, no discrimination in programs that receive federal funding, the Equal Employment Opportunity Commission, registration and voting certificates, the Attorney General can take on some cases, support for dispute resolution at the local level, and then these miscellaneous provisions. And everything I just reviewed is basically the bones of the Civil Rights Act of 1964. So I want to talk a little bit about the impact of the act, what it did change and what it didn't, and a little bit about why. And then I'll have a book recommendation to share and some trivia. So what didn't change? One of the things that happened that did not change is that the federal government still doesn't do anything very directly in almost all of the discrimination that people experience in sites like employment, restaurants, movie theaters, schools. So most of the time, the federal government, other than creating rights on paper and maintaining the federal courts, is not investigating, is not monitoring, is not directly advocating, is not taking anyone to court. Federal investigations are very limited. There's a lot more demand than supply. And one of the things that means is that regardless of what this law says, the burden remains on individuals who experience discrimination to try to then go exercise their rights, either by filing some kind of complaint or by going to court. So lawsuits, arbitration, individuals have to protect their own rights. The federal government only does a very little bit to take that on directly. So that was true before the Civil Rights Act of 1964, and that's still true now. In addition, what we see is that there's been some resistance in the federal courts to having the Civil Rights Act of 1964 be as expansive as civil rights advocates at the time intended. So some things didn't change because even though the law on paper might have a more expansive meaning, the courts refused to enforce it and instead developed a more restrictive interpretation of the law. So some things didn't change because the courts resisted enforcing the law, sometimes. Some things didn't change, particularly in the arena of public schools, because so much of the access to schools that a student has and the resources that a school has to offer a student are still determined by your tax bracket, zip code, where you live, and we still see massive racial and economic segregation in US neighborhoods. And so a formal ban on school segregation doesn't eliminate the reality that there are major disparities in how schools get funded and who can go to which public school. In practice, therefore, we still see elements of school segregation just remaining today. It's just not a formally acknowledged policy based on race. The Civil Rights Act of 1964 was also restricted further at the state level as states banned certain kinds of law, not all states, but some states banned certain kinds of laws which would have helped to combat discrimination. So what I mean specifically is the body and package of civil rights laws known as affirmative action laws, which was a term that described removing barriers that were discriminatory in areas like education, public accommodation, and employment. So some states implemented bans that basically said you can't engage in these practices. You can't have these non-discrimination requirements. And as long as a federal court didn't overturn it, they were allowed to do that, and it limited the impact of the Federal Civil Rights Act of 1964. One other reason that the Civil Rights Act of 1964 had less impact than it could have was that a lot of the dynamics of discrimination are what we call intersectional. So for instance, there were a series of federal court cases that were dealing with the question of whether you could certify a group of workers to represent a class of people in that workplace. So getting what's called a class certification means that a court says, even though you only have 7 people who are workers from this workplace who want to sue, and there are 1,000 workers, they are representative of the group. You know, we wouldn't get all 1,000 people signed up to have a court case, but we'll allow them to sue on behalf of the whole class of people in their workplace. Okay. So class certification works in this way. And one of the things that we saw courts come up with is that they didn't know how to deal with discrimination claims which were on a compound basis. So for instance, there were a series of employment discrimination claims filed by Black women workers in the federal courts. And I'll give you these 3 examples. One federal judge, again, 3 different courts here, but all in the federal court system. One federal judge says, I can't certify Black women as a class of women because they don't represent anyone other than Black women. So I can't let them be certified to sue for sex discrimination because they're Black. And notice that we don't see the same kinds of restrictions coming up. Like I've never heard of any court saying we can't certify a group of white women as a class of people representing women because they don't represent the experiences of women of color, right? But this court basically said, yeah, we can't just recognize a group of Black women as a stand-in for all women. They're too Black to be like all the other women, right? We also saw the same thing happen when a group of Black women tried to be certified as a class of Black workers. But the dynamics that they were experiencing were only happening to Black women at this particular case. In this case, they were workers who were being last hired, first fired. And so Black women were last hired and first fired at a higher rate than either Black men or white women. And the federal judge says, well, no, we can't certify a group of Black women workers as Black workers because it's only happening to the women, not to the Black men. So they're not representative of Blacks. And then we have seen federal cases in which, again, same basic fact pattern, Black women workers who are last hired, first fired, tried to say, okay, we're going to try to be certified as a class of Black women workers, right? Let's do both. Let's say everything we are. And the court said there's no such thing. You can sue for race discrimination or sex discrimination, but we can't create a new protected class that's based on a compound identity. So you can't be recognized as women workers for the purposes of an anti-discrimination suit. You can't be recognized as Black workers for the purposes of an anti-discrimination suit, but the law doesn't recognize protection for Black women specifically, right? So intersectionality has also meant that lots of forms of discrimination have been able to persist as long as they just compartmentalize out a portion of workers. So for instance, targeting Latinx workers who are not English speaking, targeting Latinx workers who are women, targeting Asian workers who are elderly, right? These combinations, intersectional claims, have received a lot less recognition and protection under the civil rights paradigm or schema or roadmap that's been created by the Civil Rights Act of 1964. So these are all reasons why not enough changed, but some good things have happened as a consequence of the Civil Rights Act of 1964. One is some plaintiffs have gone to court and won. People have been able to use the law in the way that it was intended, sometimes by getting to the court saying, look at this pattern of discrimination, look at how I've been harmed, hold my employer or this business owner or this school accountable, and they won. And when people win their civil rights actions, one of the consequences that employers, not just that employer, but others which are watching or learning about the outcome of the case, are more likely to change their policies to try to not discriminate in the same way that got somebody not just sued, but liable for some sort of judgment or relief in a court. So those claims have changed the landscape and been a basis to do things like create mentoring programs, create human relations processes for filing complaints in a workplace, create things like sensitivity training, right? So all sorts of things have shifted in US spaces because employers and schools and public accommodations and cities and counties and states all know that they may be sued for just gross discriminations, gross acts of discrimination. The Civil Rights Act of 1964 was also successful in ending formal segregation in public spaces for the most part. So I stress formal. It doesn't mean we don't see segregation in the world, but it has to happen more informally. It's patently illegal to say to someone, we don't serve people of your race or your sex. Having, for instance, a private club that doesn't allow women, a country club with a ban on Blacks or Jews, right? These sorts of open practices were ended by the Civil Rights Act of 1964. That's not to say they couldn't still play out a little more covertly or informally, but formal segregation was ended. And again, this was basically about 80 years after the Supreme Court decision in Plessy versus Ferguson. And coupled with the Voting Rights Act of 1965, the Civil Rights Act of 1964 did serve to improve and increase voter participation. So the sort of concluding thought here is that the formal Jim Crow era of the 19th century ended, but segregationist and racially harmful practices were often reinvented or reconstructed. So the Civil Rights Act of 1964 said to private and public entities, you can no longer boldly declare that you are going to discriminate on any of these bases. But it still left a lot of room for people to find ways to discriminate without quite admitting that that's what is being done. So I want to share a book recommendation, and it's not specifically about the Civil Rights Act of 1964, but in thinking about how to kind of enter into thinking deeply about this era and thinking about the kinds of change that activists and movements and communities were pushing for and the basis for it at the time. My book recommendation is by the author Barbara Hansby, and the book title is Ella Baker and the Black Freedom Movement, A Radical Democratic Vision. So Barbara Hansby, Ella Baker and the Black Freedom Movement, A Radical Democratic Vision. For those of you in our Zoom room, I'll put the book title into our chat. So one of the things that we do with the Civics Project is in a number of our sessions, we play what's called Civics Trivia. So I'm going to briefly screen share, and those in our Zoom room will be able to follow along, but I'll still read it out for those who are with us listening to the podcast. And just one sec while I share screen. There we go. So for our Zoom audience, feel free to add your answers if you would like into the chat. So our first question is this: which public figure referred to the Civil Rights Act of 1964 as a second emancipation? Our choices are A, Thurgood Marshall, B, Lyndon B. Johnson, C, John F. Kennedy, and D, Martin Luther King Jr. And the answer on this one is D, Martin Luther King. This was him. Thurgood Marshall has some important things to say about the act as well. And each of these figures has a number of public comments, but this particular reference, second emancipation, goes to Martin Luther King. How many US senators ultimately voted in favor of the Civil Rights Act of 1964 once the 75-day filibuster was ended? And our choices are A, 73, B, 51, C, 100, or D, 60. And the correct answer on this one is A, 73. It had almost 3/4 support. So it was only so difficult to pass because of the minority resistance coming from Southern senators who wanted to maintain segregation and kept us noting introducing hostile amendments and then filibustering when that didn't work. And 3, what Supreme Court case first tested the Civil Rights Act of 1964 on constitutional grounds? And our choices are Brown versus Board of Education. That's A. B is Heart of Atlanta Motel Incorporated versus United States. C is Burgerville versus Hodges. And D is Planned Parenthood versus Casey. And the answer here is B, Heart of Atlanta Motel Incorporated versus United States, which originated, as you can imagine, with a motel in Atlanta, Georgia, which was arguing that it had a constitutional right to engage in racial discrimination in its motel. And it lost the case in the Supreme Court. It lost in December of 1964, so later that same year after it was passed. Became considered the landmark test case that established that the Civil Rights Act of 1964 would be understood as constitutional. Brown versus Board of Education, as noted, was decided 10 years before 1954. Burgerville versus Hodges was decided in this millennia and basically protected same-sex marriage. Planned Parenthood versus Casey was a Supreme Court decision that limited the scope of Roe versus Wade. So our case that tested the Civil Rights Act of 1964 was Heart of Atlanta Motel Incorporated versus United States. It was heard in fall of 1964 and decided in December of that year. And for those of us joining us in Zoom, I am sharing some additional links if you would like to learn more, and I'll be sure to share those in the chat as well. I would like to invite everybody to join us next week. Our topic is sex education, specifically sex education, law and policy. This won't be a sex ed seminar. We'll be learning about the law and policy governing sex education. Our special guest next week is Jackie Latta, who's a longtime sex educator based in California. And that session will be led entirely by our team of student interns. So I hope you'll attend and give them your complete support. They'll be taking over my role next week. And then come back and join us for more on civil rights on the 25th of this month, where we're going to be interviewing a special guest, Brandon Butler from the California Department of Fair Employment and Housing. And our session that day focuses on fair housing law and policy. So again, thank you to everybody, and Repair will be resuming its full programming calendar in April. We're expecting to have 9 events next month, so follow our Eventbrite page to learn more about what's coming up. Thank you so much, everybody, and we'll take Zoom questions in just a moment after we end recording. And to our Zoom audience, please like us and give us stars. Thank you.